Looks like Team Karen Reed has added another new face to the Dream Team. And Julie Miller, yes, that Julie Miller from Vanity Fair, has got the tea. Hello, 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 and welcome back, roommates, to Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people who have opinions about all things going on in the true crime community, including that, yes, a juror from Karen Reed's first persecution has joined her defense team. So this was published by Julie Miller. You might recognize her name. She was the same Julie Miller who wrote that fantastic two-part series in Vanity Fair where she essentially lived with her for 72 hours or so, give or take, in the same house that she was arrested in. So, in her only interview, Victoria George, this is the name of the juror, told Vanity Fair, "I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case." When Victoria George got the jury summons for the first Karen Reed unaliving trial outside of Boston in 2024, she didn't balk. A Princeton graduate who grew up obsessed with the Supreme Court, interned with a federal judge, and got her JD from Northeastern University School of Law in Boston, George says she feels a civic obligation to participate in the oft-dreaded enlistment. By the time she turned 34 last year, the employment lawyer had already served on 2 prior juries and acted as a foreperson. So not only is she extremely knowledgeable about the law in general, but she also has, it seems, pretty vast experience serving on a jury as well as a former foreperson, which can be extremely beneficial to have on your team if you're Karen Reed, right? So we're swiftly, April 1 is the jury impanelment start date. It's probably going to take a couple of weeks before we even get to opening statements. That might not happen until the end of April, I'm assuming, because of how wide the coverage has gotten, especially in recent weeks, as more and more people are starting to come out of the woodwork. Attorneys are speaking out and giving their thoughts and feedback about the first trial and the case and all the shenanigans that have occurred since then. So it's going to be extremely difficult to probably find a impartial jury, but having somebody like Victoria George on your defense team would make sense from a strategic perspective, almost like a jury consultant, right? George had heard about Karen Reed, the Massachusetts woman, was all over Boston media as a prime suspect in the mysterious 2022 death of her Boston police officer boyfriend, John O'Keefe. Norfolk County District Attorney Meatball Michael Morrissey charged the then 42-year-old equity analyst with second-degree unaliving manslaughter while operating under the influence of alcohol and leaving the scene of a personal injury or death. So those 3 counts, because again, the M2 and the leaving the scene of personal injury were not dismissed. Prosecutors alleged that in a drunken rage, she had fatally backed her SUV into Officer John O'Keefe and left him to die in a blizzard. As Reed told Vanity Fair last year in a 2-part feature, she believed that she was being framed as part of a cover-up involving Morrissey, Massachusetts State Police Detective, or former now, Michael Proctor, right? And I'm especially excited for him to get back on the stand. I don't know if he's going to end up pleading the fifth or not on some things, but I feel like now's the opportunity, Chip. Now's the opportunity. Everybody wants to throw you under the bus. Now it's your turn to throw it right back at him, honestly, because there are way more people that need to be held accountable outside of you. As disgusting of a human being you are not the sole person to blame. There are many, many people who are responsible for this utter, ridiculous clown show. George, who joined Reed's legal team on Wednesday, so today, was too busy caring for her 2 small children and grieving her mother who died in 2023 to pay much attention and was therefore qualified as a juror. I was able to be a juror because I believed that the state court system was going to give her a fair trial. And as we see now, especially from Hank Brennan, that it is more important that the Commonwealth, Massachusetts, gets a fair trial than the actual defendant being prosecuted with a crime. And again, and Colin Albert, I mean, I can't tell you how many times, I would love to know how many times the name Colin Albert came up during the hearing the other day when they were discussing and arguing the third-party culprit defense, which I don't think she ruled on whether or not, Beverly Canola Oil ruled on whether or not the defense will be allowed to present their third-party culprit defense. I believe they will, whether or not they'll be able to directly name the 3 witnesses that they have as potential suspects that could have been if they were properly investigated by Chip in the first place. I've been trying to continue to believe in justice for a while. I mean, I assume that's why she became a lawyer, because she believes in the justice system. Which, again, I feel like having her on your team just gives you so much more of a greater and deeper insight. George is a conscientious rule follower. Once during the trial, after she drove past a free Karen Reed billboard outside Gillette Stadium, she told Norfolk County Superior Court Judge Beverly Canola Oil to make sure she was on the up and up. The court assured she was. Well, that's good. So she's saying, hey, I did see the sign. If that, makes me, if that takes me out of the running, then take me out of the running. I want to make sure that she gets the fair trial, right? During 9 weeks of trial, she says that she and other jurors stretched conversation limits to avoid talk of the case, which could not begin until deliberations. When another fellow juror began to openly criticize Reed before deliberations began, according to several jurors, she and her peers reported the person to Cannoni. The juror they reported was dismissed. For George, the fulcrum trial moment was when Massachusetts State Police Trooper, now former State Police Trooper Chip Proctor, the lead investigator, let's say it again, the lead investigator on, not the customer service representative or the case officer or what have you, right? The record keeper on Reed's case, read aloud the text messages he had sent friends and supervisors only 16 hours into the investigation. There will be serious charges brought on the girl. She's a whack job. See you next Tuesday. Zero chance she skates. She's ducked. No, sir, you're ducked. When someone on the text chain surmised that the homeowner on whose property O'Keefe was found would surely receive some shiz, as well, Proctor responded, nope, homeowner's a Boston cop too. Proctor later called the text unprofessional and regrettable. As I'm reading this, right, I'm just wondering if Hank Brennan is like, oh man, now I gotta file another motion to get the interview notes from this Vanity Fair article as well. Earlier this month, the Massachusetts State Police fired Proctor for unprofessional conduct during the investigation and showing a bias too, because everybody thinks it's all about just the text messages. No, it's also about the shoddy investigation and the lack of actual investigating that was done. I mean, he never showed up to the crime scene. Unless, of course, you want to consider the crime scene to be the Canton Sally Port. And if that's the case, you got some splaining to do. Knowing he was the lead investigator, says George, and based on his own words, he had a pretty strong personal bias against the person in the defendant's chair. How do you ever trust the evidence coming from his investigation? That was a question that a lot of people have on their mind, too. Exactly. It's like, and two, why did he have such strong feelings about David Yannetti? As revealed in court earlier this month, the dismissal was prompted by Massachusetts State Police Officer John Fanning, who has been accused of potential jury tampering. One of Proctor's supervisors, who Reed's lawyer Alan Jackson says had been on the whack job text chain. While huddled at sidebar to discuss the reason for the jurors' dismissal, Reed's lawyers Jackson, David Gannetti, and Elizabeth Little learned that Fanning, an investigator on the case working at a Morrissey's office, had that morning reported an alleged incident he had not personally witnessed that supposedly took place several weeks prior. There was no evidence presented at the time. As the court knows, Jackson told Cannoni during a fiery exchange in his motion to dismiss argument on March 5th. There was no declaration, there was no report, there was no supporting documentation whatsoever over the defense's objection. This was very potentially defense-friendly juror was then excused. I asked the court to take evidence from Lieutenant Fanning. The court declined that invitation, and she ultimately did dismiss the motion to dismiss yesterday, and without any evidentiary hearing. She's very, very committed to that April 1 start date, and one can only speculate as to why. Cannoni did not dispute Jackson's recollection of those events, but asserted that Fanning did not have direct or indirect access to the jury. And it's like, well, hey, why don't we just ask him? Why don't we just ask him? Now, I am curious if any of this could potentially come in, but he is on the defense witness list, so that base is definitely covered. In the state of Massachusetts, alternate jurors are selected at the end of the trial, several hours after the aforementioned juror's dismissal. The clerk magistrate rotated a box on a spindle and pulled out 2 tiles. He did not show the numbers to the court, but said that they belonged to George and the other juror who had reported the critical juror to the judge. George, so interesting, right? George requested a sidebar, so this is interesting, with Cannoni, and she recalls saying that their dismissal from the voting pool did not seem like a coincidence. Cannoni declined to comment for the story. Of course she did. And of course, Karen Reed's defense attorneys can't respond to this because they have a gag order. George had hoped her legal skills could be helpful in the deliberation room, as they had during a previous trial during which she served as a foreperson. So I'm assuming this is why she was able to speak with Julie Miller as well, too. I don't know how far back they've been speaking with each other, but if Victoria George, Bev can't really do anything about it, right? She's a practicing attorney in Massachusetts. Karen Reed has a right to choose her own counsel. The only reason why Betterow wasn't allowed in was because he was coming in pro hoc vice. So Bev could technically deny him being allowed to join her team. But from what I've seen from some of the law tubers that have been covering this case as well, it doesn't seem like this will be a issue. So after, I guess, this article, that gag order would apply to her as well. I'm not sure how that would work, but it seems like this story has probably been percolating and brewing for quite some time. So what a time to drop it, right? George had hoped her legal skills could be helpful in the deliberation room, as they had during a previous trial, during which she served as a foreperson. In the state of Massachusetts, the judge chooses the foreperson based on a number of factors, such as attentiveness through trial and demeanor. Other times, the decision can be made arbitrarily based on seat number. And I don't know how I feel about the judge choosing, like why it just can't be randomized. But I mean, in this particular instance, it's clear that she was selected as a foreperson in a previous trial. She would be more than qualified to, and also she's an attorney, so she's going to naturally be a little bit more alert and paying attention and understand certain things that maybe somebody like myself wouldn't be able to understand as easily. To preside over the fate of Reed, a woman being charged with fatally yada yada, Cannoni selected a retired Boston police officer to act as a foreperson. calling it out. Let's call this shiz out. It's nice to see a mainstream media journalist in a huge publication like Vanity Fair call it out for what it flipping is. During the trial, according to 2 jurors, the cop told his peers that he had been hit by a car. I mean, we saw this in, again, the Ashley Benefield case, where there was a juror who did serve on the deliberating jury. Ashley Benefield was convicted, right, of unaliving her husband, despite her claim of self-defense. And one of the jurors had lied about her previous experiences of DV in her family, as well as I think she also had a couple arrests under her belt too, like related to that. So that would make her potentially biased. And the judge had an evidentiary hearing. They called her back in. The attorneys were able to question her. Ultimately, Ashley Benefield was still sentenced, whereas this was not the case. So it's like, here's this clear conflict of interest. One, you're a former Boston cop, right? You're the foreperson. You're also the same guy who's telling jurors, like, oh no, like about the notes that they were sending in, right? When they were given the Tui Rodriguez instruction. And that's how that whole mess kind of started to spiral down. So I didn't know that he was hit by a car. That's crazy. According to multiple jurors who have come forward since a mistrial was declared, there was confusion in the deliberation room about whether or not jurors could declare a partial verdict. Again, so this goes back to lack of understanding the jury instructions, which were extremely confusing to follow. And also having somebody as the foreperson dictate how to communicate to the judge, right? So there's a lot of these little things in between that makes having somebody like Victoria George, I almost said Victoria Judge, Victoria George on your team, and they can use that information to help during jury impanelment for sure. Even though, and ask better questions during cross-examination as well too, right? Even though the jurors were unanimous in deciding Reed was not guilty of M2 and leaving the scene, they were split on the manslaughter charge. Yet, the letter from the foreman that canola oil read aloud in the courtroom indicated they were deadlocked on the charges, because she was like, don't come back to me unless you've come up with a verdict on all charges, plural, and a mistrial was declared. Reed has appealed the verdict, claiming that her constitutional rights are being violated by being tried for M a second time. George has 4 children under 5, including infant twin sons, and had no desire to come forward. I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case. But it bothered her that much that she's like, I can't keep my mouth shut. That's amazing. What does that tell you? During the March 5 pretrial hearing, Jackson argued that Reed's case should be dismissed for reasons of extraordinary government misconduct, including Proctor's bias, investigative failings, the suspicion of jury impropriety, and the fact that some video evidence was withheld from Reed until January 2025, and it's still just coming out now in drips and drabs. It's absolutely crazy. Absolutely crazy. On Tuesday, Canola Oil rejected Reed's request for an evidentiary hearing about the recently surfaced video, which the Commonwealth has called an oversight, right? And denied Reed's motion to dismiss because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismission, and because the defendant's constitutional rights can be fully protected in the coming trial. Not with hanky-panky, tell you that. But it was how Hank Brennan, the special probiotic Morrissey, appointed to try Reed this time around, responded to Jackson's allegation of jury tampering that compelled George to speak up. She's like, I am sick and tired of the lies. Or the gaslighting, as David Yannetti freaking called him out in court the other day, right? I think it was Yannetti, right? Brennan, who previously defended Whitey Bulger in federal court, suggested Reed's claims of extraordinary governmental misconduct were dangerous and reckless and nefarious, with the potential to cause the public to question the fabric of our entire judicial system. It's just so ironic to me that the guy who built his entire practice on fighting government corruption is now the same guy who's like, yay, government corruption, let me help the bad guys. It's just wild to me. And after yesterday's hearing, I can't imagine in any world how many people are going to be clamoring to hire Hank Brennan as their defense attorney, because either he's going to go back to doing what he was doing prior to this case, or Meatball's like, if you rub my back, I'll rub yours, hanky panky. Not to put that image in your head, but I mean, I just don't. What is he getting out of this other than a paycheck? Unless he just hates himself that much, I have no idea. George tells Vanity Fair attorney Brennan implied that the defense was responsible for causing sentiments of distrust in the justice system simply by questioning inconsistencies, yes, and putting together a defense for their client, because that's what you do, right? Inconvenient facts and missing evidence. At that point, she decided, if as a lawyer I was too afraid to stand up for what I believed in, who would? Well, Ducking said, we applaud you, madam. Even after the circumstances of her dismissal from the deliberating jury pool and the contested mistrial verdict, George had been hopeful when Brennan was assigned to the case. The respected Boston lawyer released a statement last fall saying that one of his core obligations was to make sure certain that Karen Reed receives a fair trial. Yes, I do remember that statement. And the dignity and fairness that every defendant deserves in our criminal justice system. Says George, I was impressed by his background and naively thought that he would see the overwhelming evidentiary issues with the case against Karen Reed. At minimum, I thought he would encourage the Norfolk County District Attorney's Office to dismiss 2 of the charges, given constitutional double jeopardy concerns. That's what honestly, a lot of us thought too. There's no way, right? There's just no way we're gonna do this whole thing the exact same way all over again. Really? And that's exactly what's happened, and it's even worse than what we thought too. So I don't blame her for being naive considering his background. George was bothered by another seeming constitutional right at risk in Reed's case, her entitlement to the defense of her choosing. So I guess the Mark Betterow that ticked her off. It ticked a lot of us off too, right? Earlier this month, Canola Oil denied Reed's request to add Mark Betterow, a former Manhattan assistant district attorney, to her team because Betterow represents Aidan Carney. Canoni determined that Reed retaining him would constitute a conflict of interest that is not waivable. George called Jackson shortly after seeing the ruling to express her mounting frustration as Reed's second unaliving trial approaches. George joked that she is still licensed to practice law in Massachusetts should Reed need an extra hand. Over the course of the conversation, the suggestion became less of a joke and more of a potential reality. On March 26, Reed filed a motion to add, so that's today, to add George to the team. The case has garnered so much media attention, and I mean, right now she's not technically on her team, so I guess she can talk to the press. She can talk to whoever she damn well pleases, right? She is not under any gag order as of now. The case has garnered so much media attention, so many polarized reactions, that George hopes the public and future jurors can remember that 2 things can be true at once. What happened to John O'Keefe was a tragedy, says George, but just because something is sad doesn't mean that the person in the defendant's seat is responsible. I can feel bad for his family and believe she's not guilty at the same time. Well, Ducking said, holy smokes, great article. I love that Julie Miller is coming back into the service at the perfect time. You can shake your fists and stomp your feet as much as you want. and shove as many, erasers in your nose, Hank Breenan. But at the end of the day, we are swinging, and we are swinging stronger than ever before. And if you're down with that, make sure you hit that subscribe button. Make sure you hit that notification bell so you do not miss the next Karen Reed update from me. And make sure you hit that like button, because that tells the YouTube algorithm that this is newsworthy news, and it is. It is. When I started this channel, I really didn't think that I would still be talking about this case, still covering it. And here we are. Here we are. I moved into the place that I'm living in currently right now, covering this case mid-trial. So it's really so bizarre to me that we are still here. We are still fighting, but we are fighting stronger than ever before. And if you want to support Karen and her defense team, because it ain't cheap. And now everybody, I think, is essentially working for free, because she's in some serious debt, obviously, with all the just how expensive everything is, including experts. I mean, this is how much money we've all raised so far, of the $2 million goal. So let's get to it, right? Let's help Team Karen Reed. If you want to do it, I always share the donation link in my description box. And Turtle Boy as well too, right? He's got a lot on his plate that he's been fighting for. I share both of those in my description box. So if you want to help both of them out, with cash or with just sharing this story with as many people as who haven't heard about the case, that helps as well too. So that being said, thanks so much for watching. See you in the next